Good morning, all. Is this the correct link that we're on for this morning's class?
Good
Because I think
morning.
I just
This the second link that he sent to me, so I think this one is the right one. Boy, stop.
Okay, that's what happened is I was trying to send out a link as well because the one we had initially was 6 o'clock.
okay. I just received another one, so we have to log into this latest link that was sent in.
No, just we in this one, so hopefully everybody will join this. We just see in a couple minutes.
Okay.
Because I think only one person is missing. Let's see. Symphony. 1, 2, 3. So let's just see if she comes in. How are you all this morning?
I'm good.
Good.
I'm tired.
Oh
Wow.
Lord.
If we're being honest, I'm tired.
Yeah, for Saturday morning to have to be up to do the same.
Well, actually, my mom isn't doing well, so I've been dealing with her. So
Oh, sorry to hear that.
yeah.
Okay, yeah, so you're tired. So you had a chance to look at the cases?
Honestly, no, I haven't. Not as yet.
Okay, but you received it.
I received them. Yes, I have.
Okay. All right, so I don't know if y'all want to do a recap quick, and hopefully I hope that Ms. Gardner is gonna come into this link. So you know what a company is? Just off the top.
Association of number of people or persons.
And would they come together for some?
Economic or charitable purpose.
Right, so they come together for a common purpose, for an economic or charitable purpose. What Solomon's principle is?
That the company is separate and apart from its members and shareholders.
Right, so that's a separate and distinct legal personality from its
Yes.
members.
Yes.
And how do we find out if a company is an agent or it's acting on its own? What questions we may ask, and what case tells us about that?
The case is Smith, Stone and Knight Limited versus Birmingham Corporation.
Mhm.
And we would ask questions like who is conducting the business, who appointed the persons, who receives the profits.
Who's the head and brains of the venture, all of that?
Yes.
Because it now demonstrates if this is an agency relationship instead, eh? And
Yes,
what will cause the courts to lift the veil or pass the veil of the company? Under what circumstances?
Where they're trying to conceal the true facts.
Right, and how they'll do that? When they'll find that out, what circumstances will cause them to lift the veil? You know, in a group of companies where they're acting as a what?
Of the staff.
Like a single economic unit. You remember those ones, the instances?
Yeah.
What else?
Agency.
Where they're trying to evade the right of relief of who? Third parties, remember that?
Provisions of limitation and the rights.
And the limitations conduct that is imposed on conduct by law. Yes.
Yeah.
Can a company be liable, civilly and criminally liable? Since it's only a legal person, can it be?
Yes, it can.
And how can it be liable? How would you attribute liability?
Under corporate liability,
right? And how you would attribute it? How would it be attributed? Who would it be attributed to at least?
The company itself.
No, we need, remember this only a person, this a legal person. So in order for us to attribute liability, we need a judicial person that we'll be able to attribute this liability to. So who we gonna look to? The person who has the what?
Most shares.
Oh, remember the direct in mind and will? Remember that point would be raised when we say the directors or whoever is controlling, they're gonna try to go to that person who has the direct in mind and will of the company, who's controlling the company. So we need to pull a director out, eh?
Okay,
Or somebody who has control. So when I sue the company, I can't take the company to jail, eh?
no,
Right, so I have to pull somebody out who has control of the company in order for me to attribute that liability to.
okay.
And then what they could be liable for? What we call it, two liabilities.
the contracts and the torts.
Contract and tort, and contract is usually under civil and tort is usually could be attributed in criminal. Can there be a director can be liable jointly with the company?
Yes.
But we'll call him then.
Thought fees,
The
though.
tortfeasor,
And he's a what? What kind of tort fees is he?
Joint.
Right, right. Now, what comparisons we can do with the company as compared to other going concerns, economic going concerns, where we distinguish a company from some other concerns? Why would you use a company as compared to a partnership?
I didn't get the question.
Why would you use a company instead of a partnership? Why would I use a company for my business instead of using a partnership?
Just want
Because
an
the
example.
Yeah,
Because a company goes on.
right, so it has perpetual succession and existence. And what else? Any other thing?
you want to also have
limited
limited
liability.
liability?
Right,
Yeah.
what kind of liability I want to?
Limited.
Right,
Unlimited.
limited liability. Unlimited
okay.
is the partnership, eh?
Right, okay.
What about a sole proprietor? Why wouldn't I want to be a sole proprietor compared to a company? What is the advantage of me being a company compared to being a sole proprietor?
A sole proprietor with his company.
That one in class too.
Yeah, you're in class too. With a sole proprietor, the company dies when the owner dies.
Right, so we at least can carry on with the company, notwithstanding one of the members may have died, yes? And what acts cover the companies? What acts we can incorporate these companies under? What laws govern the company?
International. Hold on, I think I know this one.
the bar,
The International Business Companies Act 2000 as amended, and I don't remember the second
Right,
one.
the Companies Act in 1992 as amended.
right. So we usually call International Business Companies Act the IBC Act,
Okay,
and then we just say Companies Act, okay? Okay, so we did a quick recap of Unit 1. We can move on to Unit 2 now. You have a good grasp of Unit 1, eh?
yes, ma'am.
Okay, and in unit 2, we should be able to understand the features and characteristics of different types of companies, including international business companies, IBCs. Distinguish international business companies from Companies Act companies, gain awareness of the uses of international business companies, develop a comprehensive understanding of the legislation relating to international business companies, and develop practical knowledge on the administration and maintenance of international business companies. So we start with, everybody read, so we start our rotation from the bottom and go back up then. So I think, Ms. Gardner, you joined us?
Yes, ma'am, I'm
See
here.
an iPhone.
I'm-
Excellent. Okay, so you want to begin for us, please? Or you're not at your book?
So I'm reading from types of companies. Hello?
Yes, thank you.
Okay. Types of companies and international business companies.
Yes, from
Learning
types of companies, thank you.
after completing this unit. Hold on. I'm in the right thing, right? Oh, no, 2 types of companies.
So you're just gonna start from types of companies, right?
Okay, number 1, private company or limited company. Company limited by shares, a company where the liability of its members to contribute towards the payment of its debts is limited to their investment in the company. 2, company limited by guarantee, a company where the liability of its members is limited by its consultation, example, memorandum and articles of association, to the amount that they have undertaken to contribute to the asset should the company be wound up. A company limited by guarantee does not have a share capital as there is no contribution required until winding up. Additionally, these companies have members, not shareholders, as for a company limited by shares. Since companies limited by guarantee have no share capital, they are private companies and not public companies. Under strict scrutiny, there is no restriction on such companies trading. However, this company structure is primarily used for nonprofit companies and is widely used for community projects, sporting associations, and educational and charitable purposes. Through the membership in companies limited by guarantee may fluctuate, though the membership in companies limited by guarantee may fluctuate, such companies do enjoy limited liability and separate legal personality, thus allowing the ownership of property and contractual rights and obligations without attracting personal liabilities to its members. The Articles of Association govern the membership of companies limited by guarantee, inclusive of the duration of their membership and any events which will terminate the company. Non-profit/not-for-profit companies, a type of company limited by guarantee used for a charitable purpose or charitable purposes, where its constitution, memorandum, and articles of association prohibits the distribution of profits to its members, either by way of dividend or in a winding up.
Okay,
Hybrid
so
company.
we have a company limited by shares. So where we have a company limited by shares, the liability of its members is to contribute towards the debts of the company is only up to the amount of their investment. Remember, we said that yesterday, Thursday, only on the paid up shares on what they would have invested in the company, that's where their debts stop. So if I only put $100 in the company, you can't get more than $100 from me. Okay, so it's only up to the paid up capital of their shares. Limited by guarantee. So what they say about limited by guarantee, the company does not have a share capital. There's no contribution required until winding up. So these people, they don't have to put anything in upfront to get this company started. Yes?
Yes,
They don't
ma'am.
have shareholders because the company doesn't have shares. They're just members, more or less. And these are usually private companies and not public companies. So they use them for sporting associations, like foundations, charitable purposes, because usually the not-for-profit companies are usually for churches or NGOs, things of that nature. So everything terminates with the company, the membership, everything stops. So usually in these companies, you only can come in through that, it's as if you're invited in. It's not out for the public just to come in at their will. It has to be decided by the membership. So you don't just come in and do as you, or I can just offer you shares. It doesn't work like that. It's usually a closed group of persons. And you just can't pass your interest on to someone else because it doesn't work like that. It's not for profit. Any questions on those companies? Okay, go ahead.
Okay. Hybrid company. A company limited by shares and guarantee is a hybrid company. Example, a company limited by guarantee but also has share capital. Public company. A company formed in order to enable the investing public to share in the profits of an enterprise without taking any part in its management. A public company may be a company limited by shares or a company limited by guarantee and having share capital. Such companies must comply with the requirement for a public company under the relevant provisions of the Companies Act 1992 in relation to such companies. Since a public company may offer securities to the public, although it is not obliged to do so, it is distinguished from a private company in this aspect, as a private company is prohibited from offering its shares/securities to the public. Additionally, the regulation for public companies is stricter than the regulation for private companies due to its ability to offer securities to the public and in protection of the public interest regarding the sale and purchase of such securities.
So the public
Statutory.
company, we usually would see them, they have to list through the Securities Commission. They have to be regulated because now you've invited the public in to purchase shares. So you're now subject to scrutiny of the regulators. Unlike with the private companies, that's within a certain group of persons. But now when you out there selling shares, everyone, the regulators have to be sure that you're viable and not running a scheme on the general public. So that's the difference with the two. That's the main difference right there. So they'd be more regulated. And public companies, you give me an example of a public company, because everybody knows the public company is in.
AML Group.
Right, so now you could purchase shares in AML Group. So as much as you don't have any control in there, you just a shareholder, somebody else runs the company. It's just for the public to invest and perhaps receive some profits as the company grows. But you really don't have any say in as such, because you're not really a majority shareholder and you just will attend meetings to see what's going on. But unless you have a big stake in it, you really won't have much to say. All right, let's move on.
Okay,
Question.
sure.
Sorry, can I have an example of a hybrid company, please?
Say it again.
Have an example of a hybrid company?
So a hybrid company is one like a gas and electric car. You have both shares to the you have shares and you have persons who guarantee the company as well. So it's limited by the guarantee of persons. So you may have that in a public company as well, because just say, for instance, you have, let's see who we could use, who may have that. They have guarantees, because some companies start up where they're not viable enough to be able to go out to the general public. So their majority shareholders or founding members may provide a guarantee as a part of the offering to regulate themselves with the securities board. So you would have, just say, AML was starting up and they said they were going to the public. So they had to show how viable they were. They said, now we want to put out to the public because we want, we need so much to purchase stuff. So let's say our port development. Whenever they start out, they go ahead and they offer shares to the public. And I think it was our key where they offered the shares and they bought it back from the public, and the company turned it again. So when they started out, there to show that they had so much investment in the company. So probably let's say 5 of the founding members may have put up a guarantee as well in order for the company to move forward to be put out to the public to purchase shares. So they're to say, well, you know, even though we're sending it out to the public, we can guarantee they'll get their money back, because what we're going to do is put in a guarantee. Remember, we talked about that yesterday, where some people may put in a personal guarantee. In this case, they have shares and they also offer a guarantee. So up to a certain point, if the company were to dissolve, they guaranteed its debts up to a certain point. So they have shares, they may have preferential shares, and they have that guarantee in there. So by the time as the company really gets off the ground, and you have already, as general public, you gave them, let's just say they made an offering and they wanted to get $1 million from the general public. So the general public gave them $1 million. They were able to start their pot up, get all the things they needed to get. They had money, but it wasn't sufficient to give them that liquidity. So now that you've joined, they got your money for about a year or 2. Let's just say they took it for 3 years just to make sure they balance out. Once they would have balanced out, they have more than sufficient just from the profits alone to go ahead and to pay you your money back with a dividend. And now they have the company on their own. So their guarantee is still in there, because they still have guaranteed the company up to the $1 million they sent out to the general public. And they have their preferential shares for anybody, any new investors they may now offer shares to. And they may go back out to the general public, but the guarantee is still in place, and they may reduce the guarantee once they would have sufficiently satisfied the Securities Commission or whomever that they are now, they've satisfied the debts to the general public and go from there, or they can always keep that in place. So that's what it is, more or less. You've given a guarantee as well as you have shares in the company. So the shares may be for the general public and the guarantee may be up. So you may say, I'm in this company and I'm only going to put myself out there, expose myself for up to, say, $200,000. And I have 5 members who's going to do that. So at any given point, we have $1 million. We'll be able to satisfy our debts up to $1 million. Is that clear?
Yes, ma'am. Thank you.
All righty.
So a company could essentially offer its shares to specific groups of persons. Not
That'll
really
be private. That'll be in a
to the public?
private.
Private equity.
Yeah, that'll be a private company.
Okay.
Mhm. Any other questions? Okay, let's go ahead.
Okay. Statutory company. A company with unique features of limited liability, which is created by a specific statute or legislation. Example, segregated accounts company, limited duration company. A, Segregated Accounts Company, Segregated Accounts Company Act, 2004. A company which remains a separate legal entity may create segregated accounts, each a segregated account, such that the assets and liabilities of each segregated account are separate from the assets and liabilities of each other segregated account. A SAC consists of a general account or core cell, the general account, which contains assets and liabilities which are statutorily separated from the assets and liabilities of the other segregated accounts and one or more segregated accounts.
So what you see them doing here in this instance?
They are risk protecting themselves.
Right, so now we separating the accounts, eh? So don't come inside account A looking for money for account B, notwithstanding we are all one company, it's segregated and the law protects them, eh? Because it's statutorily separated, and then you can incorporate a company as a segregated account company. All right. Okay, let's move on.
Okay, one moment, let me turn this. Sorry about that. And international business companies. International business companies, IBCs, are corporate vehicles designed for commercial, corporate wealth management, property holding, trading, insurance, and investment purposes for business persons who wish to leverage their unique features. In addition to the foregoing purposes, IBCs may be used as part of a complex arrangement of trusts, foundations, family offices, and other specialized vehicles for financial planning, private client, and wealth management objectives. International business companies are incorporated in the Bahamas under the International Business Companies Act 2000 as amended. The International Business Companies Amendment Act 1984 for limited duration companies. Under IBC legislation, IBCs are no longer prohibited from conducting business with Bahamas residents or from having an interest in or lease real property in the Bahamas. They remain versatile corporate entities or international business. No person, entity, or other than a bank or trust company licensed under the Banks and Trust Companies Regulation Act 2000 shall incorporate an IBC unless such person, entity is licensed and approved under the Financial and Corporate Service Providers Act 2000 as amended. IBCs may maintain bank accounts with banks operating within the Bahamas, subject to customer due diligence, know your client, and certain documentary requirements. They may also establish and maintain professional contact with attorneys, accountants, and any other consultants who practice in the Bahamas.
Okay, so unlike the domestic companies, these companies can only be incorporated where the person or entity is licensed under the Financial and Corporate Services Providers Act 2000 as amended. And it's designed for commercial, corporate wealth management, property holding, trading, insurance. It's usually a vehicle that is used by persons offshore and not onshore. While some Bahamians may now look at the IBC, it really was designed for investment purposes and for persons outside of the Bahamas to utilize this vehicle. So you would find that mostly in the investment area where there are trusts, they usually use these international business companies because of the reporting requirements and all the features of this IBC. It's a little bit more expensive than a domestic company because the regulators know that it's for investment purposes. So it's that some fees are usually charged additionally, like when you can request a document from the registry for a company, may cost you $50, it may cost you $100 for the IBC. They get struck off quicker than the regular companies as well, because they have to comply strictly with what they're supposed to do. But we'll read more as we go on. Okay?
Okay. Go ahead. Hello.
Okay. So let me give somebody else, because we already utilized you. Thank you so much.
No problem.
Okay.
No problem.
All right, so now we go to, let's see who's next. We're going back up. Who's next? It's Symphony, it's Dominique now, Roberts. Dominique. No.
Incorporation.
Okay.
Yes.
Yes, go ahead, please.
Incorporation. Incorporation formalities for IBCs are simple and are concluded in a relatively short period of time, given the online e-services provided by the Registrar General's Department. Normally, after the company name reservation, inclusive of payment of the name reservation fee, and upon submission of the relevant constitute documents and payment in the incorporation fee, whether manually or online. Incorporation is completed by registration by the Registrar General at the company's registry of the Registrar General's Department of a memorandum of association and articles of association to which at 2 persons or more persons have subscribed for shares to the memorandum of association and a certificate of compliance. Upon registration, the registrar issues a certificate of incorporation. The IBC is then legally in existence and may commence operations immediately. Similar to the incorporation process for a Companies Act company, one of the first steps in incorporating an international business company is to confirm the availability of the proposed company name and reserve it at the company registry of the Registrar's General Department. Generally, a financial and corporate service provider, FCSP, registered agent, RA, or the general public may reserve a company name and any business names which will be included in the company's register. However, only registered agents, RAs, may actually incorporate a company. Under Section 3 of the IBC's Amendment Act of 2014, the IBC Amendment Act, the name of the intended company may consist of words, a combination of words and numbers, or contain a dual name, which may include an English and foreign name. The English name need not be a translation of the foreign name. However, where a foreign name is used, the applicant for the name reservation and subsequently the company must provide the translation of the accents, characters, and distinct marks, script, and symbols used in the foreign name. The fee for dual name reservation is $50. The company name is reserved initially for 28 days, and the name reservation can be extended for 2 periods of 14 days each. It is a statutory requirement that the company name be reserved prior to incorporation, and a valid registration name is entered into the incorporation application form. The fee for the standard name reservation is $25. However, the fee for an extension of a name reservation is $30 for each extension. It should be noted that the new IBC Amendment Act allows any person to forego the name reservation for an intended company. Registered agents seeking to incorporate companies must either complete the HTML form online or upload their own memorandum of articles of association. Additionally, registered agents must upload their certificate of compliance. It is optional for the registered agent to upload and provide the registrar of directors or officers at incorporation, but it is a statutory requirement that the register of directors and officers be filed. The incorporation fee for an IBC is $400 for capital up to $50,000 and $1,200 for capital over $50,000. And the annual government tax / fee for an IBC is $350 for capital of $50,000 or less, and $1,000 for capital over $50,000, which must be paid on or before the 1st of January of each year, and is subject to a penalty fee for late payment within a specified time period. The turnaround time for incorporation of an IBC using regular e-services is 24 hours, and for expedited incorporated e-services, 1 hour for an additional fee. The annual fees for an IBC may only be paid by the registered agent, and the annual fees for any given year are due on or before the 31st of December of the preceding calendar year. IBCs may be struck of the Register of Companies for non-payment of fees by the 31st of December. It should be noted that fees may be accepted for IBCs for the current year or a future year. However, no fees will be accepted for a current year unless all outstanding fees for prior years have been paid.
Okay, so we now have the incorporation formalities for the IBCs. So they say it should be for a relatively short period. I know they say 24 hours, but usually it's 48 hours at least. You would get that turnaround time from them. it's important that you see it's only done through these registered agents who are licensed under the what? Where they have to be licensed in order to incorporate this IBC.
The Registrar General.
No, where they have to be licensed, would we say? They have to have a what license? Right on the page before. Would we say? Financial and corporate service providers license? You see it? FCSP, so it has to be a financial and corporate service provider. You see
Yes,
that? Yes,
that's
Okay,
in
so-
paragraph 4, I think. Yeah.
right, so you should know that. Remember, we have that on, right under international business companies, where you have to be a financial and corporate service provider. So they usually, financial and corporate service provider, you get that license under Securities Commission, okay? And then they can subscribe. Who has to subscribe? How many persons can subscribe to the memorandum and articles of association?
2 or more.
2 or more, right. Once the registrar, so you have to prepare a memorandum and articles of association, or you can use the format that they have. And additionally, which you must have. What else you have to provide the registrar with?
A certificate of compliance.
Excellent, with a certificate of compliance. So we have to show that we've complied with all the regulatory provisions of the IBC Act in incorporating the company. So certificate of compliance says we have a person who is 18 years or older, of sound mind, and not bankrupt. One of those, one of the subscribers that is. And the objects and the purposes of the company, what are they being incorporated for, is nothing unlawful under the laws of the Bahamas. Okay, so it's a similar process to the Companies Act, but we also have to reserve the name, right? And once we reserve the name, it's done through the registered agent, and then we upload the documents for incorporation. What about the name of the IBC? What they say about the name? Can we have an English and a foreign name?
Yes.
And if it's a foreign name, what happens then? If we use a foreign name, we have to also put in the English name, the English translation, eh? And
Yes.
we pay for both. So the fee reservation is $50 when we use an English and a foreign name. Now, if you have reserved the name, but you're not ready to incorporate, you can ask for an extension because your name reservation only lasts for 20, how much days?
8.
28 days. So after, before the period is ended, you request an extension and you have to pay $30 for that extension. And you can do that extension twice. That's the limit of it. So you can do it 2 times thereafter. After that, you'd have to start over. So it's 2 periods of how much days each?
14.
Excellent. The first, when you reserve, how long it lasts?
28.
And so if I reserve it, if I want to extend it, I can extend it for an additional 14 is $30, and an additional, a further 14 will be another $30. So we have also at the time of incorporation, you can upload your register of officers and directors if you have the persons who you know are going to be officers and directors. If you don't know at that time, you would file it later, but it's mandatory that you file the register of officers and directors with the Registrar General. That's one of the requirements of you as an IBC. That's like with the regular companies, you have to file annual returns and declaration of beneficial ownership. You have to file the register of officers and directors with the Registrar General. The incorporation fees for an IBC is an IBC is $400, where the capital is up to 50,000 and over 50,000, it's $1,200. The annual government fee, which is due on or before the 1st of January of each year, is $350, where your capital is 50,000 or less, and it's $1,000 where your capital is 50,000 or more. There are penalty fees if you don't pay these fees within a specific time, and I think your first penalty is in April. At the end of the year, if you haven't paid your fees, you're automatically struck off the register, and you would have to pay for the company to be restored in order for you to continue doing business. So you have penalties all throughout the year if you don't pay your fees by the 1st of January. And at the end of the year, December 31st, they strike it off the register. So by the time it's the 1st of January of the next year, you have to pay all those penalties, the fees, and the restoration fees in order for you to move forward. Okay? And you can't pay for 2022 coming up if you have not paid 2021. You have to pay for the year prior in order for you to move forward. Any questions? Okay, we can continue then.
Types of IBCs. An IBC may be 1, a company limited by shares, 2, a company limited by guarantee, 3, an unlimited company, 4, a limited duration company, 5, a segregated accounts company. Memorandum of Association. A memorandum of association provides the name of the company, the location of the registered office of the company, the location of the registered agent, a statement of objects, the authorized capital, and defines the classes of shares to be issued, a statement of the number of shares to be issued as registered shares, the currency in which the shares are to be issued. The ultra vires doctrine does not apply. Hence, there is no need to delineate all the objects of the company. A statement in the memorandum of association to the effect that the object or purpose of the company is to engage in any act or activity that is not prohibited under any law of the Bahamas makes any act or activity that is not legal, illegal, part of its objects. IBCs can amend their memorandum and articles of association by shareholders or directors' resolution as and where permitted. Only registered shares are allowed for an IBC. Bearer shares are prohibited.
Okay, so we have the IBCs. What should be in the memorandum and article, memorandum of association. So the memorandum is the document that sets out the objects of the company. So in particular, the name of the company is usually in there. The registered office location would be in there. The location of the registered agent, the statement of the objects. Now the statement of the objects because you didn't want the company to act beyond its powers, which is the ultra vires doctrine. So they can't go beyond the power or authority that they have. What they've done is they've incorporated this statement, which gives them a broader outline of what objects and purposes the company may be engaged in. So it's to engage in any activity, any act or activity that is not prohibited under any law of the Bahamas, makes any act or activity that is not illegal part of its objects. So in that instance, I can do anything that is not prohibited under any law of the Bahamas. So I could sell shoes, I could buy and sell investments, I can do all those things.
Adi, how much you to pay for that low man last night? Oh, sorry.
As long as it is
Sorry.
within the laws of the Bahamas. Additionally, the authorized capital and defines, and the classes of shares are defined. So if the capital is 5,000 divided into 5,000 shares of $1 each, and you would say the currency as well. And then a statement that the shares are to be issued as registered shares, because the company is no longer permitted to have bearer shares. Bearer shares would mean that there's no particular name on the share, it's only marked bearer. So whoever held the share certificate, they were the owner of the shares. You're the bearer of that share and you're the owner of the share. And they can amend, the IBCs can amend their memorandum and articles of association by a shareholders or a director's resolution wherever it's permitted. So if it's permitted in accordance with the articles to say these memos, this memo and article can be amended by resolution of the shareholders or resolution of the directors only, or by both shareholders and directors. And there's no, of course, only registered shares are allowed. Any questions? Okay, let's continue. Let me see. Okay, I think Dominic didn't give us 2 pages. Okay, so next. Right before Dominic, we have Chryseria.
Hold me, please, sorry.
Okay, so Chryseria, Sanika Box Martin, please.
Okay. Share capital. There is no minimum authorized capital required for IBCs. The authorized share capital of an IBC may be divided into various classes of shares, each with different voting, dividend, and other rights. Capital may be, denominated in any currency. Shares may be issued in fractions in registered form only, and may be of no, par value. Unnumbered shares are permitted. In addition, in certain circumstances, IBCs may purchase, redeem, or otherwise acquire their own shares. An IBC may, in certain circumstances, reduce its capital by resolution of its directors and with the necessity for an appropriate order of the court.
Okay, so the IBC is, there's no minimum authorized capital required for the IBC, so that's important to note. So in some instances, I may, what I could do, I may say I only have a share capital of $100, or I may say $10, so there's no minimum authorized capital. It can be divided into various classes of shares, each with different voting, dividend, and other rights. So I can have 100 shares, and I may divide those into voting and non-voting shares. I may say only 10 of these are voting shares. I may say 10 of these are only going to be divided into as $1 shares, the next one 10-cent shares. So you can, it's any fraction, you can divide those in. So that's what they usually do. But these IBCs, especially when they're using them as funds, so mutual funds, they would split them up in order for you to have a lot of shareholders. So you may have 10-cent shares, and you may have 50,000 shares, $50,000 divided into 50,000 shares of 10 cents each. So you can go like that. So it'll be something of that nature. The IBCs may purchase their own shares, they may redeem their own shares, or they can acquire their own shares, the company as a whole. And they can also reduce the capital by a resolution of directors, or where it is necessary, the court may order that the capital is reduced. Any questions on share capital? Okay, let's continue.
Shareholders and shareholders meetings. There need only be one shareholder of an IBC. There are no nationality or residency requirements for shareholders, subject to a contrary provision in its memorandum and articles. Meetings of members may be convened by the directors or by the members holding more than 50% of the votes or such lesser percentage as prescribed in the memorandum and articles of association, and may be held within or outside of the Bahamas. Members may attend in person, by proxy, by telephone, or by other electronic methods. All meetings may take place within or without the Bahamas.
Okay, so the shareholder need not be a resident. And we only need to have one shareholder. Why we distinguishing that is because in a Companies Act company, you need to have two shareholders, a minimum of two. And if it's gonna be a foreign person, you need to apply to the central bank for them to hold shares in a Bahamian company. And the IBC is, you don't need that. They can be of any nationality or resident. They don't have to be Bahamian nationality or resident. And again, the members holding 50% of the votes or lesser percentages as prescribed in the memo may conduct meetings, and the meetings may take place in person, by proxy, by telephone, or any other electronic methods, because now we have virtual meetings, right? And the meetings may be within or outside of the Bahamas. Okay, let's move.
Directors and directors meetings. In IBC, an IBC is only required to have one director, who may be an individual or a company, and such director need not be a Bahamian resident. The number of directors are fixed in the Articles of Association, subject to any limitations in the Articles or Memorandum of Association. The subscribers of the memorandum elect the first directors, and the memorandum or articles govern subsequent appointments. A director must be given not less than 2 days' notice of meetings of directors. The inadvertent failure to give notice of a meeting to a director, or the fact that the director has not received the notice, does not invalidate the meeting. The quorum is fixed by the memorandum and articles of association. Meetings are convened by the directors and may be held within or outside of the Bahamas. Directors may attend in person, by telephone, or by other electronic methods, and all directors participating in the meeting are able to hear each other and recognize each other's voice. By both of these criteria being met, participation constitutes prima facie
A prima facie.
proof of recognition. The directors have all the powers of the company that are not reserved to the members in IBC Act, the Memorandum of Articles, or in any anonymous shareholder agreement. The directors may, by resolution of directors, fix the emoluments of directors in respect of service to be rendered in their capacity as directors, subject to any limitations in the memorandum or articles or in any anonymous shareholder agreement. IBCs may indemnify their directors against all proceedings against them, provided they acted honestly and in good faith, with a view to the best interest of the company.
Okay, so the IBCs, the directors again, we distinguishing between the Companies Act company and the IBC. The IBC is only required to have one director. And it may be an individual person or a legal person, so natural or legal, a company or an individual. And the person does not have to be a Bahamian resident. The number of directors are fixed by the Articles of Association. So usually they tell you this is required to have a minimum of one director and a maximum of 9. So that's where the fix. So usually you would look in the articles to see how many directors the company is required to act in any instance. You would look to see powers of the directors or the directors in the Articles of Association. The subscribers are the ones who are the what? Who we say the subscribers are. They're the first who.
The first person is appointed director,
Right, but who are the subscribers in the company?
shareholders,
The first shareholders, that's correct. So they're the ones who would now appoint the first directors. So in order for the company to get started, we need the subscribers to appoint the directors, and the directors run the company after that, eh? Director has to give not less than 2 days notice of a meeting. However, if he's failed to do so, that will not invalidate the meeting. A quorum for the meeting is also fixed by the memorandum and articles of association. So usually the quorum will say, in order for this meeting to proceed, we need to have at least 50% of the directors present, or we need to have 50% of the members present. They can convene the meeting inside or outside of the Bahamas, as we said before, by telephone or other means. And the directors have all powers of the company that are not reserved to the members in the IBC Act, right? And of course, they may have a shareholder agreement that may provide, but that's relative to the company setting that up. The resolution of directors may fix the emoluments, which means like the salary or fees that a director may be paid in respect of the services they render to the company. So in some instances, there may be no fees for these directors to collect, so they won't mention it. But in most instances, directors are paid for their services. And of course, the directors usually look for indemnification for their actions taken once they've acted in good faith and in the best interest of the company. They're looking for themselves to be indemnified against all proceedings as far as it concerns them executing their duties as directors. Any questions? It's clear? Yes, maybe so.
so far so good.
Okay, let's continue then.
Anonymous shareholders agreement. This is a written agreement
Oh,
prepared
that's
by
that's unanimous.
unanimous shareholders agreement. This is an agreement prepared by all the shareholders of the company, which restricts in whole or in part the powers of the directors of the company to manage the business and affairs of the company. A shareholder who is a party to any unanimous shareholder agreement has all the rights, powers, and duties, and incurs all the liabilities of a director of the company to which the agreement relates. To the extent that the agreement restricts the discretion or powers of the directors to manage the business and affairs of the company, and the directors are hereby relieved of their duties and liabilities to the same extent. When a unanimous shareholder agreement is executed or terminated, written notice of that fact, together with the date of the execution or termination thereof, must be filed with the registrar within 15 days after the execution or termination, and no such agreement shall be legally effective until notice of its execution shall have been filed as aforesaid.
Right, so why you think we need a unanimous shareholder agreement?
Because everyone that's holding shares would have to come together and agree for it to be valid.
Right, but why we would want to execute a unanimous shareholder agreement? We already have shares in the company, what we need that for? What we say about these shareholders? They only have shares, eh? Who runs the company?
The director,
Right, so why we doing this is we want to restrict in whole or part, or in part, the powers of the directors to manage the business and affairs of the company, because you will find that as much as you're a shareholder, the director have the say. They tell what they're gonna do, whatever it has to be done for the company. And they may hold you up from doing what you need to be, what you don't, so in an instance where you don't agree with them, or where you want to make certain decisions, you would put the shareholder agreement in place. So in that instance, when I have that, I now have all the rights and powers and duties of the directors. And then additionally, I incur all the liabilities of the directors, okay? But it's important in smaller companies in particular, where you may be the majority shareholder. You may have your family members as directors. So because of in an instance of a Companies Act company where you need to have at least 2 directors, you may have, whereas you say I'm a director and she's a director and we only have 2 directors. So I can't make any decisions because I need both directors to sign. So I may put in place a unanimous shareholder agreement because I hold 80% of the shares, and I'll say basically the rights, powers, and duties are reserved to the shareholders. So I won't be beholden to that other director who's gonna hold me up to say, well, as much as I don't have any real stake in this company, I can hold you hostage from getting things done. Or if you die and you would have left a will, you were the only other director. So now only the nominee, you might as well say director, is left. They can hold up the whole process because they can say, well, nothing can be done unless the directors appoint the new shareholders and the like. But if I had a unanimous shareholder agreement in place, then the shareholder would be the person who would now make that decision and not the director. And it won't leave the company held hostage as such, where there was a requirement just to hold the director who's only acting as a nominee and now wants to hold up the whole company. So the shareholders agreement, when you've executed that, where should that be? What you have to do with that, so that not only,
Wanna
file
keep
it
it,
with the registrar.
right, that's
Yeah.
important that
it
it's
should be
filed.
public.
Right, because what is public? What is public what is a public document that's already there? And when I go to the bank, they're gonna be looking at that. What they're gonna look at in order to see what powers we have.
The memo and arts.
Right, so the memo and arts was filed on incorporation. So I need to ensure that this other document is also a public document to let the world know. So this is notice to the world that as much as they are directors, I am the shareholder and I have the powers, rights, and duties of the director. So they don't have any power over me here. I have the final say as a shareholder. So that's why it's important to have it filed. And what is the timeline to get that filed? On execution or termination?
15 days.
Right, within 15 days. So that's important to note. Okay, let's go on.
Confidentiality. The The IBC still affords a high degree of confidentiality since there are only limited filing requirements for an IBC. It is only the name of the company, its registered office, and that of its registered agent's name and address. The company's memorandum and articles of association, including any amendments, as well as the names and address of the company's directors and officers that are filed with the government. The, the names and addresses of the company's shareholders are only registered in the share register maintained at the registered office of the company and are not filed or registered in any public register in the Bahamas, and therefore provide the investor with total
I was
privacy.
like, I thought I did leave my laptop charging, you know.
Okay, so have you seen my laptop charging? Because I had a string just like that, but like it's not as long and it's not as thick. And it's from my
I think Braxton moved it, you know, because I remember putting this in here.
Continue.
Oh, last night when I was eating.
Dorset.
Okay,
I want to look around.
so
Should I continue?
Sorry, I couldn't hear you. Sorry. Go ahead.
Registered office, registered agent, and registers. An IBC is required by law to maintain a register.
Okay, before you move on, confidentiality. What we say about confidentiality, what is important to note? That,
That it only has limited filing requirements.
right, so the shareholders' names are not made public, eh?
No, ma'am.
Unlike in the regular company, the shareholders' names are public. Okay? And so that provides the investor with privacy, and that's one of the main features what they use those IBCs for, because they want it to be private. Go ahead.
Registered office, registered agent, and registers. An IBC is required by law to maintain a registered office, Section 37 IBC Act, and a registered agent in the Bahamas, Section 38 IBC Act. Minutes of meetings and copies of resolutions of directors, members, and officers, a register of directors and officers are to be kept in the registered office. An IBC must have a corporate seal, an imprint of which must be kept at its registered office. The company must notify the registrar of any change in the name or address of the registered agent.
Okay, so we have guidance as to where we can look in the IBC Act for these requirements. So the registered office is under Section 37 and the agent is under 38. What else they must keep there at the registered office?
A stamp, a seal with the
Right,
imprint.
so if they don't have the seal there, they just need to make sure an imprint is there. They should have copies of what?
The resolution of directors, members, and officers.
And the register of directors and officers are to be kept at the registered office. And where there's a change in the registered agent, what we must do?
It must be notified, we must notify the registrar.
Right, so that's important. And it's a fee usually when you're changing these things in any event, because you have to send notice to the registrar and there's a fee to file that notice. Okay? Any questions?
You know, like Ms. Darcy, is it, can you also see these things online as well?
Which one? Which thing? Tell
Like
me.
the shareholder agreement and stuff like that? Are you able to see those things, or just you'll be able to just see the
No.
IBC like that, to see paper?
I don't think they're up to date as they should be, because a lot of times you go in there to do a company search and a lot of things are not available. So it's still physical. You have to go there physically to see the file. Because you pay that $10 online to say you see in the file and nothing is really uploaded there. They've not completed that system where they would put all the documents online, where you can actually get a copy of documents online. They're not there yet.
Okay, so
Alright.
basically, like, So basically, like anyone could go and get it, the information if they so desire.
Right, remember this these public documents, whatever on the file is public, so you can just go there, pay your $10 for the hour and go through the file, and then you can pay for copies of whatever you want on the file.
Okay, but they haven't gotten that digitalized as they need to be.
Not where it should be. Only what is
Okay.
uploaded on there by the registered agent or office is usually available. What is not
Okay.
uploaded, you don't find there.
Okay.
Okay,
Okay.
any other questions? Okay, let's move on.
Company compliance. In addition to the payment of annual government fees, IBCs must maintain copies of the memorandum and articles of association, register of directors and officers, and share register at their registered office. The register of directors and officers and any subsequent amendments must be filed with the company's registry of the Registrar General's Department.
So that's further documents in compliance that should be kept at the with the registered office agent. We should have a copy of the memo and arts. We should have the share register. So as much as that's not public knowledge in the registry, the registered agent and the office should know who are the shareholders. So that should be at the registered office or agent's office. And any amendments thereafter should also be kept on the file in the registered agent's office. Okay? Okay, let's go ahead.
Additional features. In addition, several other beneficial features are enjoyed by IBCs. Some of them are exemption from stamp duties other than stamp duties applicable with respect to real property transactions, ease of merger and consolidation with other companies incorporated in the Bahamas or with foreign companies, minimal statutory filing and reporting requirements. Its assets may be transferred in trust for the benefit of its creditors, shareholders, or other persons having an interest. IBCs may hold securities in other Bahamian companies. Securities of an IBC may be held by anyone. Dividends may be paid in money, shares, or other property, and only out of surplus, and for the purpose of determining such surplus, the net unrealized appreciation of assets of the company may be included in such calculation. A foreign company may provisionally register with the registrar of companies to become and to be continued as an IBC once predetermined conditions are met. Transfer by continuance or to another jurisdiction. Transfer of by continuance from another jurisdiction without reciprocal arrangements with the jurisdiction of incorporation. Exemption from exchange control regulations for non-Bahamian owned IBCs. Usage of any of the words limited, corporation, incorporated, associate, any anomy.
Don't worry about it. So it's Societe Anonyme, Sociedad Anonyma, or any of the abbreviations Limited Corp, Inc., or SA as part of the name of the company. Go ahead.
The IBC legislation.
We could have come to like 12:30. Okay. But I didn't want, yeah, I didn't want.
You will go ahead, Ms.
Oh, okay. The IBC legislation also allows companies already incorporated under the Companies Act of the Bahamas to continue as IBCs provided that certain provisions are met.
Okay, so we have,
Want one? Take one.
so we have features. These are features that the IBCs enjoy And so these are comparing them to the Companies Act companies. Okay, so what are some of the features? They're exempted from stamp duties, other than stamp duties applicable to real property tax transactions within the Bahamas. Yes, so that's a big feature that could take you a long way because you're really not doing business here in the Bahamas, eh? You have ease of merger and consolidation with other companies in the Bahamas or with foreign companies or of other jurisdiction. You can easily do that with the IBC, under the IBC Act. You have, the IBCs may hold securities in other Bahamian companies. So the IBC can hold shares in another Bahamian company. There's minimum statutory filing and reporting requirements. So we know that from what we say, they don't have to file so many documents. They only the register of directors and officers needs to be filed. Securities of an IBC may be held by anyone, because what we say about that? Why we say, why that's a feature?
So, no nationality or residency
Right.
requirement?
Right. Excellent. So dividends may be paid in money, shares, or other property only out of the surplus, and for the purposes of determining such surplus, the net unrealized appreciation of the assets may be included in such calculations. Foreign company may provisionally register with the Registrar of Companies to be continued as an IBC, so you can continue from another jurisdiction. So an IBC and BVI may continue here in the Bahamas once they meet the conditions. So usually they ask for a legal opinion to say that the company is in good standing with BVI before it continues here in the Bahamas. It is exempted from exchange control regulations for non-Bahamian owned IBCs. So that's only where it's non-Bahamian. So you can have a US dollar account. You don't have to worry about getting exchange control approval to hold a US dollar account where the IBC is owned by a foreign person. And it can only continue, it can continue even without reciprocal arrangements with the jurisdiction of incorporation. So notwithstanding the Bahamas may not have a reciprocal agreement, they can still continue here in the Bahamas. You can also use those endings, Societe Anonyme or Sociedad Anónima, Limited Corporation Ltd, as a part of the name of the company. And companies that are incorporated under the Companies Act may also be continued as IBCs. So I may be a Bahamian, have a company under the Companies Act, and may want you benefit from some of the advantages of an IBC, and I'll continue as an IBC. Any questions? We good? Okay, let's answer the questions. What are the two types of limited company? Where we'll find that answer.
Page 21.
Page 21. Okay, what are the two types?
Company limited by shares and company limited by guarantee.
Excellent. Define a non-profit company, where we'll find that answer.
Page 22,
Page 22.
paragraph 3.
What is a non-profit company?
A type of company limited by guarantee used for a charitable purpose or purposes, where its constitution, memorandum, and articles of association prohibits the distribution of profit to its members either by way of dividends or in the winding up.
Excellent. Number 3, define a public company, where we'll find that answer.
Page 22, paragraph 1, 2, 3, 4, 5.
Okay.
A company formed in order to enable the investing public to share in profits of an enterprise without taking any part in its management.
Excellent. Okay, what primary Bahamian legislation is used for the incorporation of an international business company, IBC, in the Bahamas? We will find that answer.
Page 23.
Page 23. And what is that?
Bahamas and the International Business Companies Act of 2000 as amended, and the International Business Companies Amendment Act 1984.
For limited duration companies. Number 5, what are some of the purposes or reasons that an international business person may have for incorporating an IBC? We will find that answer.
Mhm. Is it page 23?
Page 23, what page 23 say?
Under IBC legislation, IBC are no longer prohibited from conducting businesses with Bahamian residents or from having an interest. Oh, no, I don't think that's it.
Okay.
I don't think that's it. Nothing in. For some purposes,
Is it one of the answers is because they can maintain bank accounts operating within the Bahamas?
Where that is?
On page 23, the last paragraph.
Mm-hmm. So what we say, we have features of the IBCA.
That's your features.
So let's look at page 28. So me as an investor, look at page 28. What it
The
says.
exemption from stamp duties and other
Mhm.
stamp duties applicable with respect to the real property transactions.
So all these features would be attracted to them, eh?
Yes.
Oh,
Yes.
okay.
In addition to them being able to conduct business anywhere in the world, in addition to them only having to have one director, in addition to them not having to be a Bahamian resident, all those things. But these features are stand out, eh? So some of the purposes or reasons, we can put those, any one of those in addition to what we already know. Upon registration, the Registrar General issues a blank for an IBC. What do they issue? We will find out.
Corporation, that's on page 24.
Page 24,
Third paragraph.
third paragraph. And what is it?
Upon registration, the registrar issues a certificate of incorporation. The IBC is then legally in existence and may commence operations immediately.
Okay, you all got that?
That's all.
Okay, number 7. IBCs may amend their memorandum and articles of association by blank or blank resolution as and where permitted. Where we'll find that answer. Where that is?
That's on page 25.
So you look on the top of 26?
That's on page 26. IBCs can amend their memorandum on articles of association by shareholders or directors' resolution as and where permitted. Only registered shares are allowed for an IBC. Bearer shares are prohibited.
So that's that's page 26 too? That's because
Yes,
you're going
ma'am.
straight to number 8 for us.
Oh, I'm sorry. Yeah.
Okay, so we answered number 8. Only registered shares are allowed for an IBC. Bearer shares are prohibited.
Mhm.
Everyone has those?
Yes, ma'am.
On 9, an IBC is required by law to maintain a blank and blank. Where would find that?
Mhm. Let me see.
Page 28 at the top,
Mm-hmm.
to maintain a registered office and a registered agent.
Okay, and what section of the ARC help us with that?
The registered office, section 33, section 37,
Uh-huh,
and the registered agent would be section 38 of the IBC Act.
excellent. Number 10, the blank and any subsequent amendments must be filed with the company's registry of the Registrar General's Department.
That's also on 28. The second
28,
paragraph. Mhm.
say it again,
That's also on 28, the second paragraph.
what it says?
The register of directors and officers
Mhm.
and any subsequent amendments must be filed with the company's registry of the Registrar General's Department.
Everyone got that?
Yes, ma'am.
Okay.
Can you repeat that, please?
On page 28,
Second paragraph.
Okay, thank you.
okay? List 4,
Ms. Dawson.
say it again, sorry.
The
Hello?
Ms. Dawson. Hi. Do we need to print off the IBC Act?
Well, I mean, you could just refer to it without having to print it. I mean, it's easy. It'll save you paper and you can just read off
It's
of it.
easier to
If you save it as a document, you can always refer to it.
Okay.
Okay, list 4 additional features of an IBC. Give me 4.
Minimal statutory filing and reporting requirements.
Where we'll find these now.
Page 28, last paragraph.
Excellent. Okay.
Exemption from stamp duties other than stamp duties applicable with respect to real property transactions. IBCs may hold securities in other Bahamian companies and transfer by continuance to another jurisdiction.
Okay. Now list 4 distinctive features of IBC compared to Companies Act company.
An IBC only requires one director.
Okay.
And
what happened with the Companies Act company?
A company requires 2 or more.
Okay. Give me another thing.
An IBC doesn't have to be, it can be a foreign, the directors doesn't have to be Bahamian,
Mhm.
whereas
Or
for the
or the
company-
shareholders don't have to be Bahamian. The owners of the company don't have to be Bahamian.
no, ma'am.
It could, and the companies are companies, if they're not Bahamians, they have to do what? Make application to the
to-
central
to-
bank.
Right, they have to do an application to central bank.
Okay, what about filing requirements? IBC only has to file what?
They only have to file, certain, okay, trying to find that. They only have to file the name of the company, its registered office,
So
and
they
that
only
of
have
its,
to, so they only have to file, the filing requirement is only for them to file the
Limited.
register of officers and directors, eh?
yes, ma'am.
Now with the regular companies.
I'm sorry, I think I have a glitch in the Zoom link.
Okay, you can hear us? Hello? Hello? So the regular company has to file annually their annual returns and their declaration of beneficial ownership. The IBC only has to file a register of the office and directors once. Unless they change it or they make any amendments, they don't have to file any documents thereafter,
Okay,
okay? What about,
That's the private
what else
clear.
about the IBC?
I'm not sure about this one, but the meeting of directors,
Mhm.
they don't have to be there in person. As long as it meets the,
Or you mean they could hold telephone? Okay, no, that could happen in the Companies Act company too.
okay,
What else we have? We have names, eh? They have these names they can put on. The Companies Act companies can't put those. So
foreign names,
endings. Right, the endings, the foreigner names and all that stuff.
oh, okay.
What about the fees on incorporation as well? The IBC is
It's
required.
more,
Right, it's more for them to do, and their penalties are, they have penalties as compared to the companies, our companies' fees, they don't have penalties.
okay,
If they don't pay, they don't have penalties throughout the year. They only get struck off after a period of time. What about the companies, our companies and the IBCs having to have a registered agent? Do companies, our companies need a registered agent? Who has to be licensed under the FCSP Act?
oh, no,
I know
they
they-
don't have,
No, so anybody can incorporate a Companies Act company, say Bahamian. They don't need to be registered as a financial and corporate service provider. But the IBC has to be, and they must have a registered agent in the Bahamas, eh?
the IBC,
Yes, under section 38 of the IBC Act.
okay,
The Companies Act company don't need to have a registered agent, okay? So we know the features and characteristics of different types of companies, including IBC companies. What we have about those segregated account companies as an IBC, what's distinguishing about those? What feature is there with that segregated accounts company? Remember the segregated account where they separate the accounts from each other?
Yeah, so
then
the
I
features
can't
that,
go over from A company to B.
Yeah. yes, ma'am. So like each one of them holds their own
Right.
assets and liabilities.
Right, so we separate them just as if they were subsidiary and parent companies, eh? Their accounts are separated. What is a nonprofit company usually, do they have shares? Do they have shares or? Oh, hello? Did I lose everyone?
Yes, ma'am, I'm here. They do have shares.
The nonprofit, would nonprofit have?
Oh, no, ma'am, no, ma'am. Everything is
Okay.
just by membership.
Yes, excellent. So we use, this one would usually come under the one limited by guarantee. So they don't have to come up with anything up front. Okay, what about, why we'll use an IBC?
You would use it for trading, for insurance,
Mm-hmm.
for investment purposes, wealth management,
And
or for business persons who wish to leverage their unique features.
excellent. So in administering and maintaining the IBC, would we have to ensure that we have at the registered office?
The registered office and agent's names and address.
What we should have at the registered office, what we should ensure we have?
The director, a list of the directors and officers,
Mm-hmm. What else?
Does the memo
certificate
not
of
go there as
compliance,
well?
Right, memo on arts. What else?
the certificate of compliance,
We should have copy of that. What else we should have copies of?
The seal,
An imprint. What else? What about the resolutions?
at the registrar general's office?
No, the registered office.
Oh, the registered, oh,
Remember,
okay.
I talking about us administering and maintaining. We should know what we should maintain at the registered office, agent's office. We should have a copy of all minutes and resolutions
Yes,
and any amendments as well, eh?
yes.
Okay, any questions? This chapter was a little muddy or was it a little clear?
I wouldn't say it was muddy. I have to go back over it, though. It wasn't as straightforward as yesterday's chapter for me.
No, because it's more or less like breaking it down for you to see, and it's not as, it's more or less for you to have practical knowledge of how the company works. So it's opening it up.
Yeah.
So it'd be good just to do a quick read over because
Yeah, I'm
now
gonna have to read
it's,
over again.
right, it's opening it up for you. Okay? Anybody else? So now it's the practical
Now-
side we go into. So we just have to, we just breaking it out so you can see how each part section works, okay? You remember why we'd want to have a unanimous shareholder agreement in place?
So that the directors does not have complete control over the IBC,
So that's where, so who would be in control then?
the shareholders.
And what we'll do with that agreement?
We would have to file that with the registrar.
Yes, right, and any time frame?
14 days.
Within 15 days, we have to
15
file
days.
that.
Okay.
14 days is what? For what? Extension of what?
The name,
Reservation. And what is the period they'll hold your name reserved for?
28 days.
28 days. So you see, you're getting a lot from this, eh?
Yes, ma'am.
What confidentiality features the IBC offers?
Uh, and it provides the investor with privacy.
Right, so when I'm filing the documents at the Registrar General's office, do they know who the shareholders are?
No.
No, so only the registered agent is privy to that knowledge, eh?
Yes.
All right, so once you read over, I think it'll be a little clearer. And then remember, we only adding on to what we already read in the next chapter, okay? But all this compounds our knowledge. We'll continue to build on what we do in here. Any questions? Good, we good?
Everything is good. I understand the majority of it. I just need to go over the IBC. I think another person said that too.
Okay, excellent. Okay, so I'll see you guys on Thursday again, and I'll try to send you 2 more cases just so you'd have some reading, okay?
Okay, thank you.
Okay,
Thank you. All right, take care, enjoy the rest of your day and your weekend. Be safe.
Okay, bye-bye.
Bye-bye.